Hello, my name is Madison Walcott, and I chose to do my application presentation on racial disparities in the United States legal system. I became interested in this topic because I am enrolled in a social psychology of justice course this semester, and I've learned about the increased number of racial minorities that often fall victim to the criminal justice system. Throughout this presentation, I will explain my idea on how to solve this problem and how social psychology has a great influence in the criminal justice system. It is no secret that there is a disproportionate number of racial minorities that receive lengthy sentences in the United States criminal justice system. Although African Americans and Latinos make up 29% of the U.S. population, they account for 57% of the U.S. prison population. Respectively, these minorities receive sentences more than twice as often than white Americans do, regardless of the severity of the offense. Although there are policies in place that try to combat these issues, I believe that there exist problems within the courtroom itself that contribute to these statistics. And I also included a statistic about people in prison for drug offenses and how over half of them are African American or Latino. Under the Sixth Amendment, all individuals involved in a criminal prosecution are entitled to a speedy trial, a fair jury, an attorney if the accused person wants one, and the chance to confront the witnesses who are accusing the defendant of a crime. Although this is an American-born right, this doesn't account for the fact that we live in a racist society. Prosecutors, juries, and judges may not be as impartial as we like to believe. The social psychological issues of racism, prejudice, stereotyping, and differences in culture are all prevalent in the court system. This can be damaging for those who are accused of a crime in which they are innocent of, but they fit the stereotype. Although it is the duty of juries to be impartial, can we trust that they can ignore their preconceived notions about a group of people? Also, in cases where there is jury deliberation, there can also exist the problems of groupthink and beliefs in a just world. When a jury convenes to determine a verdict, it isn't entirely irrational for a presence of groupthink, especially in capital punishment cases where the jury must be entirely unanimous. Suppose you're a juror and there are 11 other jurors deliberating about the verdict of an individual facing a capital punishment case. If all other jurors strongly state that they believe that the person is guilty, do you comply, even if you disagree? Although you are supposed to state your opinions in this situation, do you really want to be the odd man out? There exists a social pressure to conform to others in these situations. People want to believe in a just world and make the individual receive a punishment for the crime that they supposedly committed. This ties into the aspects of racism and discrimination because if there are individuals who are extremely vocal in the deliberation process that hold underlying stereotypical views about a defendant or a group of people, it brings the idea of racial disparities in death penalty cases to the forefront. So how do we stop this problem? We can't just tell people to be impartial like we have been doing. It's obviously not working. Although this is an extreme measure, I might have a solution to the racial disparities in sentencing. Perhaps making the defendant anonymous. By eliminating the physical aspects of a defendant, it might force the jury to be impartial. Don't get me wrong, physical appearance does matter in the courtroom, but can it cause more harm than good in some cases? It is difficult to defend someone who looks like they would commit that crime. Most people believe that if someone looks weird and creepy, they're more likely to do weird and creepy things. When researching this topic, I came across a story from a public defender's office. And basically what happened was that a public defender taped a mugshot of a very creepy looking defendant to the lunchroom refrigerator and asked everyone to guess his charges. Of course, everyone assumed that he was some kind of sex offender, but this was wrong. He just had the misfortune of looking like a pervert, but he was actually charged with writing bad checks. The point of the exercise was to show that if legal professionals are susceptible to falling into the trap of weird appearance equals weird behavior, then think of how a jury must perceive certain defendants at trial. And this story can kind of be translated into, racial minorities. Say that you're on a jury and somebody is facing a drug charge and they look the part, following all stereotypes, you're more likely to resort to sentencing than actually following through with all of the evidence. And so, for example, on the flip side, being conventionally attractive has its perks. People are less likely to believe that a young white woman can be engaged in a drug distribution charge than an older black man. This is the impact that stereotypes have on a case, and by making the defendant physically irrelevant, the facts of the case become more important in the deliberation rather than the appearance. So there are a few implications of making a defendant anonymous. One would be that there wouldn't exist a stereotypical aspect of the case. Without knowing the race and appearance of the person, one can't confirm any biases. This can make the process of sentencing more appropriate to the crime, for there is evidence that racial minorities are often given lengthier sentences for equivalent crimes committed by a non-racial minority. So, I read a case when I was researching about this topic, and it was between a black man and a white man. They both were charged with similar drug charges, and once the sentencing came around, it was found that the black man received a sentencing 3 times lengthier than what the white man did, because he lived in a rather racist community. So this is just highlighting the fact that racial disparities are present in the courtroom, and by eliminating the superficial appearance, this can help people like that black man. Secondly, people will be less likely to make personal attributions and focus on the relevant evidence. And like I just said, if there's no appearance available, then you're forced to only listen to the evidence provided and then make your assumptions. And lastly, in highly publicized cases where the defendant is proven innocent, their dignity remains intact. Although this anonymous policy may solve all of the aforementioned problems, I definitely have some critiques about my own argument. This policy would not work for all cases, especially in civil cases. There's often a large influence made by remorse, and I think that would be virtually impossible without having your appearance at play there. Secondly, it might violate the Sixth Amendment right to confront your accusers. I guess in theory, an individual could still confront their accusers to protect their identity, but I think it would further complicate the process, and US courts are overflowing with cases as it is. I also feel that this kind of gives a game show type of feel to criminal sentencing. The theatrics of throwing a defendant behind a curtain is very 70s dating show-esque, but maybe the tenseness of courts could dial this back a bit. And I didn't have this on my slide, but we can't forget that there is a racial disparity in policing, and this wouldn't address the fact that there are more African Americans and Latinos picked up in the field. So in conclusion, there still exists a presence of racial disparities in the United States justice system. So by eliminating things such as stereotypes, racism, and confirmation biases, we could reduce the number of minorities in our prison institutions. This is the reference that I used for my statistics and the stories that I quoted. if anybody would want to read into more about the statistics. Thank you for listening.